Honorable Minority Leader, is it not the same question that you are coming back to ask? Same question has been asked and answers provided. So for me, it is the same question that you are rephrasing. So you may answer. You may ask another question, please.
Chairman, if you want to find a way to stop this vetting, I will yield to you. Stop what you are doing. The whole country is watching you. Stop what you are doing. Stop what you are doing. If you want us to fold up, I'm not here to debate with you. I'll fold, discharge her, let us go. If that's what you want to achieve, I've seen it. And hound this house. No problem. If you are strategically planning that a Supreme Court nominee should not go through this, so be it. But this question is not out of order. I am putting a question. Please pay attention to my question. Pay attention to my question. Pay attention to the question I'm asking. I'm not asking the same question. I've done research. I've worked overnight. I left this parliament, my office, at 12 a.m. Go back here at 6. I know what I am asking. I'm not saying the same thing. For the avoidance of doubt, I repeat my question. What are the constitutional risks?
I have a short response to
Please
what
respond.
you have said. The public is not only watching me, it's watching all of us. And the jury will be out there. I cannot be intimidated by you. I'm a man with indomitable spirit. I still rule that a question has been asked. The nominee will not answer this question again. Pose another question.
My lady, are you a registered voter?
I'm a registered voter, yes.
My lady, which constituency did you register?
I registered in the La constituency. I don't know whether it's called La, but it's yes, it's at the La area, yes.
La Dadikotopon.
I don't know if
that's the full name of the constituency.
Yes,
La
yes.
Dadikotopon.
Yes.
Okay. Which area, which polling station or center specifically? The area you were trying to describe the area where you registered. Which area?
It's at La.
La proper. I know. I lived in La. That's why I'm asking. I know La very well. So which area? Is it the trade fair area, La Wireless, or where the South La Nyaniba Estate area?
No. It's not. It's within La proper. Yes, it's within La proper.
Very well.
Honourable members, I'm inclined to overrule this particular question. What we should do in vetting the judges are governed by law. Which political polling station they cast their vote, I don't think on grounds of relevance it's not required.
Lord, grant me patience. Lord, grant me patience.
Any follow-up? Thank you. I will proceed to recognize Honorable Bawumia, Junior Bawumia.
Thank you very much, Mr. Chairman. My lady, congratulations on your nomination.
Thank you very much.
My lady, you are being elevated to the highest or the apex body in our judicial system, which is the Supreme Court. Can you share with this committee 2 major decisions you've made in your career that you would be remembered for? And can you share with this committee what really the content of those decisions were?
Very well, Honorable Chair. The first I would mention is that I co-authored a judgment, Republic versus McPow. To the best of my research, this may very well be the first test case under the 1992 Constitution. My checks tell me that there's no appeal pending, but even if there should be an appeal pending, I think that this is a judgment that would chart the path and be a reference for future cases. And also, I would like to say that there is another ruling, not a judgment, that I authored in the case Letha versus Letha. It went to the Supreme Court on appeal, and the Supreme Court reinforced its previous decision in the Ojiadom case, which says that even though an application for stay of execution, even though there can be an application for stay of execution in respect of executable judgments, it is also possible to grant a stay of execution in non-executable judgments, especially so when the execution of that judgment would have executable consequences. So, thank you very much, Honorable Chair.
Any follow-up?
I'll leave it here and then say congratulations once again for your nomination.
Thank you. I will now proceed to give the floor to Honorable Anthony Imie.
Thank you, Mr. Chairman. Welcome, my lady, and congratulations on your nomination.
Thank you very much, Honorable.
My first question, let us look at delays within the administration of justice, within the courts. Could you tell this committee why so many delays with simple land matters? Sometimes some of them travel for 6 years, 7 years, 9 years. Even simple matrimonial matters, 5 years, 6 years. What are some of the reasons you would attribute for these delays?
Thank you very much, Honorable Chair. One of the very first reasons is that we do not have enough manpower to be able to expedite the cases that we have. I would give an example. When I was in the family or divorce court, at a point in time, you could have 300 and over cases, and that's just one court. And that is just one judge who has to determine all these cases. And we should remember that as these cases are being determined, new ones are being filed on a daily basis. So the first thing is lack of manpower or enough judges to be able to expedite these cases. I would also say that another cause for delay is the procedures and processes, especially the interlocutory applications. So many repeated interlocutory applications can stall cases, especially when you give when there's an application before you and you give a decision, and your decision is stayed. It means that you probably, and your decision is taken to the higher court and the case is stayed. It means that you would have to stay your hand until the matter is determined. Another thing is also that we need to be able to look at the procedures, timelines for filing, from the stage of filing of summons to the stage of filing your pleadings to the application for direction stage. Is it possible to shorten the process so that we can expedite the cases? That is
everybody to understand so as to help expedite the way and manner cases progress in court.
Thank you, Honorable Chair. For me, it's not the complexity of the rules of court, but the timelines may have to be looked at. Because if you have to file a writ of summons and statements of claim, and it will take you about 22 days for the other party to file a defense, we may have to look at it and see if we can shorten the timelines to be able to expedite the filing of pleadings. In that case, we could speedily resolve these disputes. So for me, it's not the complexity, but the timelines. Thank you, Honorable Chair.
My second question, I was trying to do some academic exercise on my own this morning, playing the devil's advocate at the same time. I looked at the CI-47, particularly Order 1, Rule 2. Then I asked myself if all the other orders following after Order 1, Rule 2 help promote the aims and objective of the CI-47 as contained in Order 1, Rule 1, 2, yes.
Well, my recollection of Order 1, Rule 1, 2 enjoins the courts to ensure that matters are speedily and effectively determined. But since the rules guide the court is guided by the rules in determining these matters. And as I have already said, the Rules of Court Committee may have to look at the timelines for filing of pleadings until when the pleadings are closed, trial actually starts after applications for direction stage. So I think the timelines may be considered. Thank you, Honorable.
My lady, my next question is, don't you think that the problem has to do with post-directions, the procedure where there are no timelines? Is that not where the problem is, where that is subject to the discretion of the court?
Honorable Chair, can I have a clarification of the question? I don't seem to.
But what I'm saying is that after the application for direction stage, there are no clear timelines. Yes, as to when trial should commence. Is that not where the problem is?
We can have timelines for completing trials, but as I indicated earlier, that would also depend on the number of cases that a court has. Because if a court has 300 cases and 100 of the cases are ripe for trial, definitely some would have to abide other cases. And that is when you are going to have a backlog of cases. So if we are going to have timelines for trial of cases, then we have to address the issue of the number of cases per judge. Then we can give effective timelines for determination of these cases. Thank you, Honorable Chair.
Thank you very much, my lady. My last question, third and last question. Your sister, my lady Janapari, was here yesterday, and as an answer to a question on the activity